Hi, everybody. Welcome back. Recall our interesting discussion about the different framing of the fourth factor of the fair use test, which looks to the impact of the use on the market or value of the work. You can also find that kind of the idea in the international three-step test, and really it's going to appear in the proportionality analysis of almost every limitation and exception. A key element of the balance in which we apply to determine whether a limitation and exception is viable is what's the impact of the use individually and cumulatively on the market for the work in question. Because recall that the incentive rationale for copyright is that we give copyright, we give a right to exclude, a right for the owner to exclude other uses of that work in order to create markets to solve that public goods problem that knowledge is non-excludable and non-rival, and therefore without some legal protection, it will flow freely. And so when we allow free uses, we may be affecting that market rationale. And so the question in every limitation and exception, and specifically in the fourth factor of the fair use test, is what is the impact of the use on the market for the work? Is every use that devalues the work, that causes some kind of harm in a market, unfair? Is that how we want? Is that how we need to determine unfairness? Are the uses that we allow, for example, to make accessible materials for the blind, is the only reason we allow those because the market is ignoring those uses? If publishers are willing to create license for research uses, for example, including for computational research uses, does that mean that such uses should be interpreted as within the exclusive rights of the copyright holder? Now, we know that many of the laws, in fact, are not so restricted, because we heard licensing presentations from librarians who testified that publishers are, in fact, very willing to grant licenses for various kinds of text and data mining uses. The problem is those licenses are very expensive, sometimes do not cover all the kinds of works that are needed, certainly cause shortages in the world. Some libraries in some countries, for some researchers, are able to afford such licenses and some are not. So what's the impact of that kind of market text within the specific context that we've been studying, where we know there's some market for licenses for the kinds of uses, maybe some failures as well? There might be some kinds of research uses, like if you wanted to crawl the whole internet, how would you license every work on the whole internet? Is that a place where really we do need to apply exceptions because there just is no possibility of having a market? But what about the various uses where there is the possibility of having a market? So an influential article in the early 1980s by Wendy Gordon suggested that indeed fair use should not apply whenever a licensing market exists or could easily form. At least that's often how that article is interpreted. Licensing, not free use, should be our general default. That article is often read to say. Our speaker today, Ariel Katz from the University of Toronto, is working on a very useful paper that both explains the complexity of Gordon's original idea, but then also flips it and challenges and reapplies some of those premises to get us to think about a different starting point and therefore lead to very different conclusions. So whether or not Wendy Gordon was actually arguing the way that I suggested is something I think Ariel will describe more deeply, but I will say that her work is often interpreted that way. Ariel's work, first of all, is a work in progress. So this is a work that I think he would very much value your input on as he continues writing it. As I'm sure you've seen, some parts of the paper are not fully developed. So Ariel, welcome. I'm really happy to have you back and to have you here in this forum. As I said, I think your article is very useful to the thinking that we're developing in this space. And I look forward to both your presentation of it and discussion. So let me turn it over to you.
Okay, thank you very much, Sean. Thank you all for being here. It's great to be here. Okay, so you already saw that first page of Wendy Gordon's paper from 40 years ago. So her paper has indeed become a classic in the sense of, judging over a period of time to be of the highest quality and outstanding of its kind to some extent, but also an important piece in the classic, in the greatest hits of copyright or copyright articles. In brief, her main or core arguments about fair use goes something like that. She said that where a defendant could not appropriately purchase the desired use through the market, and when transferring control over the use to the defendant, that is the user, if doing so would serve the public interest, and if doing so would not substantially impair the incentive to create the work, then courts have in the past considered, and should continue doing that in the future, they have considered that type of use to be fair and hence non-infringing. And in her paper, she discussed different type of market failure. So the first type is the most straightforward, that maybe transaction costs are too high, and therefore the market, the licensor and the licensee, just prohibitively costly for them to find each other and agree to a license. Or maybe because there are you need to combine together many licenses for many right holders, and that cumulatively becomes prohibitively costly. And this is kind of the first type of market failure she discussed, and the one that most people stopped reading after discussing that. But Wendy did not stop there. She also discussed other type of market failures, for example, where there are externalities. And externalities mean that when the licensor and the licensee, or the putative licensors and licensee, consider what price should be paid, each of them rationally consider their own private interests. They don't take account the benefits or costs to the public. To make it more concrete, if you are a teacher and you need a license, so you consider how much it's going to cost you to obtain a license, and that maybe it would make your work easier. But using the work can create many positive externalities. You will teach people important stuff, but the benefit that accrues to them is not something that you can internalize. So it's not that because they benefit, you are willing to pay more. What determines your willingness to pay is only how much you benefit, not how much the use benefits others. So when there are externalities, even if there is possibility of a market transaction, the market transaction would not reflect truly the social value of the transaction. Okay, so even though a license or the use could create a lot of social benefit, because you who have to pay consider rationally only your own benefit, you would be willing to pay only a limited price, and therefore you may not be willing to pay at all because it's out of your pocket, right? And therefore you would not obtain a license because it's not rational for you to do, and everyone loses. Okay, so that's another type of market failure. She also recognized that there could be some non-monetizable interests, some social interests that we want to advance or protect, and it's very hard or difficult to think about them in terms of kind of clear cost benefits or monetary terms. And another type of market failure could be strategic refusal to license, right? That it's not, a licensor is able to license, the licensee is willing to take a license, but the licensor for some other reason chooses not to offer a license because maybe they have other work that they want to promote and that they don't want people to use the particular work, or many other strategic reasons. Yeah, and here I have just a side question. I think we might think about number 3 and 4 actually as we could frame them as type of externalities, but we don't need to go into that now. Okay, and Wendy Gordon's paper made at least 4 important contributions. First of all, 40 years ago, it offered or attempted at least to offer a theoretically coherent framework for understanding and applying fair use. And did that at a time when the fair use doctrine was considered by many to be a complete mess. And Wendy Gordon offered some theoretical framework that made fair using made it possible to see it much more analytically coherent. Another important contribution was that her article pioneered the field of economic analysis of copyright. Again, today there are more people who do that. 40 years ago, there were much fewer. And it offered an economic justification for fair use, which was also something rather novel, because most people who spoke about fair use did not use economic language to do that. And it showed, or at least purported to show, that a broad conception of fair use was economically consistent with the underlying purposes of copyright law. Okay, so these were very, I think, 4 important contributions. But alas, Wendy's article had been misunderstood, or at least she complained that it had been misunderstood by many. And this is how she explains the misunderstanding. She said that the market failure test for fair use has been misinterpreted as implying that fair use should exist only where high transaction costs completely bar a market from arising. As transaction costs decrease, some argued fair use should begin to disappear. I have been incorrectly interpreted as arguing that the impossibility of arriving at a bargain is the essential justification for the doctrine of fair use. And she also lamented that for some reason it has become standard for economically oriented commentator, okay, that it had this very restrictive space for fair use, and it has also become standard to cite me for that limiting proposition, and to suggest further that my logic could lead to eliminating fair use when transaction costs between owner and user become low enough that negotiation can occur. But the logic was not to limit, the logic of her paper was not to limit fair use, she said, but rather the opposite. The goal was to show that the Ninth Circuit's holding about fair use, and she refers to the Sony v. Universal case before it went to the Supreme Court. The Supreme Court, the majority found that fair use existed, but the Ninth Circuit thought otherwise, and Wendy wrote her paper after the decision of the Ninth Circuit, and she said her goal was to show that the Ninth Circuit has taken a very limited view of fair use, limiting only to productive or transformative uses, and that had been overly narrow, and she wanted to show why economically an opposite result could have been justified. So now, exercising my fair use, I think this summarizes Wendy's lament.
But I'm just a soul whose intentions are good. Oh Lord, please don't let me be misunderstood.
Okay, so Wendy Gordon's intentions were very good, and she has been, I think, misunderstood. But why was that? And when I set to write the paper, I wrote it there was a conference 3 years ago, or 2.5 years ago at Boston University in honor of Wendy Gordon. And when I was invited to write a paper, and initially I thought, okay, well, I'm going to explain why she had been misunderstood. And then I saw 2 things. One was that she already explained a lot of the things that I thought I would say, and many of them also even existed in the original paper. But reading it again, I started sensing something that I think explains why, despite her intention, she had been misunderstood. And that's what I am going to do now. The reason for the misunderstanding was not because Wendy focused only on a narrow set of transactional market failure. She clearly did not. She did employ a much richer concept of market failure, and masterfully explained why efficient markets may fail and fair use should be found even if a copyright owner is willing to give a license and a user is capable of taking it. But I think that the reason for the source of the misunderstanding was that from some premises that Wendy Gordon had articulated about the efficiency of markets in the context of copyrighted work, and how she identified the baseline for determining what constitutes market failure. And the premises that she made, and which I'm going to explain, were faulty and really not necessary for the main point that she wanted to make. But because she made those faulty premises, those premises created this kind of sticky gravitational pull towards a very restrictive view of fair use, despite everything else that she said and despite of protests. But those premises still created this pull into this very restrictive view. Okay, so what are those premises? So I describe those three premises. I call them the market supremacy premise, the broad entitlement premise, and what we ordinarily want premise. So the market supremacy premise state that in general, and that's what Wendy Gordon said, social welfare will be maximized in market transaction between a copyright owner and users would proceed as many uses as possible, because the market in general constitutes the optimal institution for governing the use of copyrighted works. Okay, that's a first premise that she made. Another premise, the broad entitlement premise, is that a copyright owner is ordinarily entitled to the revenue for all substantial uses of his work. And the third premise, what we ordinarily want premise, is that where economic value is at stake, we ordinarily want a potential user to seek permission from the copyright owners and pay a price they negotiate. Okay, that's what we ordinarily want to happen. And only for some reason it cannot happen, or a reason to expect that if it happened, it's inefficient, only then we would opt for saying you don't need a license, you can use it freely. So let me offer my critique now of those three premises. Okay, the first is the market supremacy premise. Are market for copyright really efficient? We have here an excerpt from Wendy Gordon's article when she kind of sets the stage for explaining why we want to rely on markets. And she goes back to economists in the tradition of Adam Smith, defends society's primary dependence on markets, but arguing that individual transactions in the marketplace serve both social needs and the needs of the individual person participating. Among other contentions, they suggest that the monetary value a person places on a resource will reflect the value that the person's use of the resource will bring to society, so that voluntary transfers between individuals will create a socially desirable pattern for resource allocation. Another way of saying that, okay, if there are different assets and people can use them in different ways, those who can use them for more productive purposes, because they expect to use the asset in a more productive way, they expect to earn more money, therefore they will be willing to pay more money, and it would be worth their while to make an offer to the person who owns the asset, and they'll both be better off if the owner sells the asset to the buyer, and to the buyer who can make the best use out of it, because that buyer would be willing to pay the highest price for it. And then she goes to illustrate this point in the context of copyright. And she gives an example. Suppose there is a best-selling novel and there are producers of movies who want to produce a movie based on that novel. Therefore, among producers of varying level of skill, the producer best able to use the work to satisfy consumers' taste will be in a position to raise the most funds and thus offer the highest bid. And that is how, if we define even justification as measured by aggregate consumer willing to pay, social welfare will be maximized. Okay, we have copyright. The copyright allows the copyright owners to give the rights to the highest bidder, and that's how social welfare will be maximized. But that's a very strange way to discuss the economics of copyright. It's not the usual way when we discuss it. Usually what we describe is the problem of that works once created, they're non-rivalrous and non-excludable, and without the power to exclude, the concern is that the creator would not be able to recoup the cost of creating, because everyone will be able to copy the work freely without paying. The creator will be stuck with the cost and without an ability to recoup those costs. And we don't typically talk about copyright as this a way to how to ensure that the work gets into the hands of the higher bidder, who is a proxy. The higher bidder is a proxy to who can make the best use of it. And the reason why we don't do that is precisely because a work is non-rivalrous. Okay, so if we are thinking about how could we maximize human satisfaction, well, then no copyright would be the way. Without copyright, everyone can use the novel for whatever purpose they want. So one producer may want to produce one movie, another producer may want to produce another movie, and both of them can do that, and a third can produce another one, and everyone who wants to use the work for whatever purpose can do it without interfering with each other. So if you're really concerned about maximizing human satisfaction in the way that Wendy Gordon described it, then copyright is not the solution. Copyright actually stands in the way of that. We often acknowledge that and say, yes, that's true, but we still need to give the incentive, and this is the trade-off that we have. So in order to maintain or create incentive and maintain incentive, we give the power to exclude, understanding that that actually may result in suboptimal level of use throughout the life of the copyright. And taking one step from this weird example that Wendy Gordon used, she used an example that works very nice in the context if we think about rival goods, such as chairs or bottles or anything else that is tangible and rival in consumption. Because when we think about rival goods, the central question that we are facing and inevitably would be facing anytime is how to ensure the efficient allocation of existing scarce goods. Okay, do you see my bottle? Okay, if there is this bottle, only one person can have it at a time, right? And there is no way around that. So we need some method to decide who can use it at any given moment. And property rights plus an ability to transact through the market, we have solid ground to think that would be a good way of allocating. But Bill, also why we often opt and think that this is an efficient way to allocate goods is that also those property rights, giving or recognizing property rights, do not affect the quantity and the price. Okay, if there is a bottle or whatever number of bottles there is, whether someone owns them or who owns them does not change the number of bottles, and therefore does not change really the price. It only affects who can use. Okay, and the combination of property rights plus market ensure that those who can make the best use of it can indeed use it. But when we think about or talk about creative works, which are non-rival, then the central question is not how to ensure efficient allocation, because then the answer is just let everyone use it. The central question that we're asking is how to encourage the creation of new works. And we do that, and when we do that in the form of giving property rights or exclusive right, we do it while being mindful that those property rights means the power to prohibit copying and reduce competition, and therefore reducing quantity, increase prices. This is a price that we pay in the form of less efficient allocation in the short term, but on the premise that in the longer term, that would be more dynamically efficient. Okay, so the first problem with Wendy's premises, she used the logic of tangible goods and property rights and applied it to talk about copyrighted works, which are inherently non-rival in their consumption. Okay, so again, she said, in general, social welfare will maximize the market transaction if market transaction would proceed as many uses as possible, because the market in general constitutes the optimal institution for governing the use of copyrighted works. Actually not. Social welfare will be maximized only if, well, our first best option is not to have any copyright and let anyone who wants to use the work use it freely. That's, if we're really concerned about maximizing social utility, that's what we would want to do if we could. But if we are concerned that this may not be sustainable in terms of maintaining incentive to create in the long term, then we may opt for having something such as copyright But then, if we are concerned about maximizing social welfare, we may want to insist on transactions only for those uses that are really necessary for providing sufficient incentives and freeing up all the others. Okay, the second premise that Wendy Gordon has made, which I call the broad entitlement premise, again, she said a copyright owner is ordinarily entitled to revenue for all substantial uses of his work. Well, actually not. That's not a true statement. Doctrinally or as a matter of law, fair use is not an infringement and therefore not part of the copyright owner's entitlement. So they're only entitled to things that are not fair use. So it's not that ordinarily they're entitled to everything, but also economically, if we could design a perfect system, we would maintain or insist that a copyright owner should only be entitled to the revenue necessary to create sufficient incentive. Okay, and anything beyond that they can earn is effectively an unnecessary tax on users. So we don't want copyright owners to be entitled to all the revenue, only to the revenues that is necessary to maintain the incentive to create in the first place and free up everything else. Okay, the third premise related to that, Wendy Gordon says, where economic value is at stake, we ordinarily want a potential user to seek permission from the copyright owner and pay a price that they negotiate. And I say, no, actually not. This is not what we want. What we really want, I'll tell you what we want, what we really want. And the ziga is that we want to identify the bare minimum of unfair uses, those uses that would seriously undermine the incentive to create, attach liability to those while freeing up all the rest. Okay, that's what we really want. What we really want is not that everyone would pay for everything if they only could. No, we only want to insist of paying for the bare minimum of uses that are really truly necessary to create incentive. So back to the market failure, when the discussion starts with assuming, okay, we have copyright, which provides broad entitlement, and then there could be some problems with that, and fair use is one of the ways to fix those problems. And that is fine if your starting point of the analysis is that copyright already exists. But if we take it one step back and recall that copyright itself is a response to a perceived market failure. Why we have copyright? Because we believe that without it, the market would result in suboptimal level of works. So we intervene in that market to correct that perceived market failure. Then the intervention in the form of copyright is an imperfect one. It creates some problems which fair use may fix. Okay, but the copyright itself is a response to a perceived market failure. And if we think about that this way, we can think about fair use in a slightly different way. So if we recall that copyright itself is a response to a market failure, then what we want to ensure is that copyright applies or copyright liability attaches only to those uses that really are necessary to maintain the incentive while freeing everything else. Now the question is, can we get there? How can we get there doctrinally? Could we get there doctrinally? And I think that we could. So what I want to share with you is a case that I like a lot, from a case from the late 19th century from the United Kingdom, Hanfstaengl v. Empire Palace. And it's an interesting case. It involves something called tableau vivant. So it was a form of performance arts that performing artists would go on a stage and they would stage famous or non-famous pictures or paintings and make them live. That's tableau vivant, living pictures. Okay, so one such show was presented in the Empire Palace Theatre in London. And Hanfstaengl is the company who owned copyright in some of the pictures that had been live staged. And a reporter attended the show and reported about that in a weekly magazine. So the reporter took sketches of the of the staged pictures, and those sketches were then reproduced in the newspaper. So here's one example, here's another. Okay, that's the picture, that's the illustration from the live staging of that picture, and another one, and another one, and another one. Okay, the copyright owners sues various parties, including the owners or the operators of the theater. And the Court of Appeals find that there is no infringement. And in one of the famous judgments, one of the judges says the following. Okay, he agrees with the previous judge who found no infringement, but says, my decision is based on different and wider grounds. Copyright, like a patent right, is a monopoly restraining the public from doing that which, apart from the monopoly, it would be perfectly lawful for them to do. The monopoly itself is right and just and is granted for the purpose of preventing persons from unfairly availing themselves of the work of others. To reiterate, the court says the copyright monopoly is granted for the purpose of preventing persons from unfairly availing themselves of the right of others. And based on that kind of first principle, the court continues, we can explain many doctrines on that basis, okay? This is why fair reviews of literary works are not infringement. Okay, but I want to focus here on framing the issue of why we have copyright to prevent people from unfairly availing themselves to the work of others. And the case goes to the House of Lords, and a very short decision, the House of Lords affirms and saying, in these circumstances, in a case in which there has been no unfair use and no copying of anything which the artist can claim as his, we should find no infringement. Okay, so that case frames the issue of what is infringement. Infringement is an unfair use. But if no unfair use was made, then there is no infringement. And I think that framing is kind of remind us the limited nature of copyright. Okay, we want to attach liability only to those uses that are unfair in the sense that they really truly undermine the purpose of copyright, but otherwise other things should be free. My suggestion here is to focus, instead of focusing on fair use as an exception to liability, defining liability in terms of what is unfair use, which is, I think, what the House of Lords and the Court of Appeal did in that case. And in a way, we can say that's already in the Act, right? If we look at the American Act, Section 107, it tells us that notwithstanding the provision of Section 106 and 106A, those the provisions that grant or define the exclusive right, that fair use is not an infringement of copyright. In Canada, in a similar way, fair dealing does not infringe copyright. Okay, so if we say fair use is not an infringement of copyright, then it's just another way of saying copyright infringement is unfair use. Okay, so in a way, we already have that, what I'm suggesting, but there is a difference between the two ways of looking at copyright and fair use. So the problem with the way Wendy Gordon described fair use, and I think the restrictive pool stemmed from treating copyright as the baseline. Okay, that what we normally want, what we really want is that every use would have to be, you'd have to get permission, unless and except there are reasons to depart from that. But understanding or looking at the issue from the unfair use perspective, if we want to limit liability to only those cases that are unfair, this reminds us that the baseline is freedom, the freedom to read and listen and watch and builds on the works of others. This is the baseline. Copyright law is a departure from that. Okay, it is a legal monopoly that prevents people from doing that which otherwise it would have been totally lawful for them to do, as the court in Hanfstengel remind us. Okay, so copyright is a restriction on that baseline of freedom. And reminding ourselves that helps us, hopefully, helps us also remind ourselves that we should therefore limit infringement only to those cases that we could define as unfair, in the sense of seriously undermine the incentive to create. And I will stop here. Thank you.
Because you're making us think about what we want.
What we really, really want. Yeah.
I'll tell you what I want, what I really, really want. So tell me what you want, what you really, really want. I wanna really, really wanna zig a zig.